Welcome back to another episode of Spilling Secrets, a podcast on all things related to trade secret and non-compete law. I'm your host, Millie Warner, Senior Counsel in Epstein Becker Green's New York office. Each episode of Spilling Secrets features a panel of attorneys discussing real-life challenges, developments, and strategies related to trade secrets, non-competes, and other restrictive covenants. Today, we're celebrating Halloween with a special episode exploring trade secrets and restrictive covenants through the lens of the wizarding world of Harry Potter. Joining us for our discussion, we have an exceptional panel of 3 Harry Potter experts. First, we are thrilled to welcome Kristen O'Connor, Senior Assistant General Counsel at Marsh & McLennan and a proud Gryffindor. Kristen is a seasoned veteran in trade secret and restrictive covenant matters who protects Marsh's trade secrets with signature Gryffindor bravery and determination. Kristen, welcome to the show.
Thank you so much, Millie. I'm delighted to be here, and happy Halloween, everyone.
Next up, we have Amy Dempsey, a partner in Epstein Becker's New York office and also a member of Ravenclaw House, who applies her keen Ravenclaw mind to unraveling the thorniest trade secrets and restrictive covenant problems, particularly in litigation, and brings her quintessential Ravenclaw wit and wisdom to our discussion today. Amy, welcome.
Thank you, Millie. I'm pleased to be here today to apply some of the lessons from the secret-rich world of Harry Potter to the legal maze of trade secrets and restrictive covenants.
And last, but certainly not least, we have Jill Bigler. Jill is a partner in Epstein Becker's Columbus, Ohio office and another valiant Gryffindor. Jill splits her time between employment litigation and advice and counsel work and regularly helps employers navigate the complex world of trade secrets and restrictive covenants with classic Gryffindor courage and tenacity. Jill, thank you for joining us.
Thanks for having me, Millie, and happy Halloween to all of our listeners out there.
So I know we have a lot to talk about today and a great discussion ahead of us, so let's dive right in. Amy, maybe you can start us off. The Harry Potter series is, of course, filled with all kinds of secrets. Are there any in particular that you would analogize to trade secrets in the Muggle world?
Thanks, Millie. When I think of trade secrets in Harry Potter, one of the first things I think of is potions, with their precise and often secret ingredients and steps necessary to make them work. And in particular, Professor Snape's Old Potions book. In Harry Potter and the Half-Blood Prince, Harry has to borrow a potions book for class from the teacher's closet, and the book he ends up borrowing turns out to be Professor Snape's old book from when he was a student. The book is filled with Snape's handwritten notes, tips, and improvements to the standard potions recipes, which give Harry a distinct advantage in potion making and suddenly make him the top potion student in the class, much to Hermione's chagrin. Snape's annotations could be considered trade secrets. For one thing, they're not publicly available. As far as we know, they were known only to Snape for decades, until Harry gained access to them through a fortunate, for Harry, accident. The annotations offer a competitive advantage and have economic value by virtue of not being generally known. The rest of the class had to try to figure out all of the steps and ingredients, whereas the annotations enhanced the effectiveness and quality of the standard potions recipes. And because Harry is the only one who has access to the annotations, they give him an edge over the other students and make him the top potion student in the class, when in previous years, before Harry had the book, that was far from the case. Where there might be a problem with qualifying for trade secret status is in the efforts to maintain secrecy. To qualify, the owner of the information must take reasonable measures to maintain secrecy. Snape initially did. He stored the book in his private teacher's closet in the potions classroom. But once Snape stopped teaching potions and Professor Slughorn took over, Snape failed to remove the book from the teacher's closet in the potions classroom, which is how Slughorn ended up loaning it to Harry without knowing that the book contained anything sensitive or confidential.
Thank you, Amy. That is a great example of a trade secret. What lessons do you think Muggle employers might draw from that scenario of Snape's old book?
One of the most important lessons, I think, is that trade secret protection is not set it and forget it. It's an ongoing process that requires updating and continual maintenance. Snape made an effort to secure his book. He didn't leave it out in an unsecured location that anyone could access. He locked it away in his private teacher's closet in his classroom, to which only he had access, and that method of securing the book worked for a really long time. But Snape appears not to have had a process of regular review and inventory of his confidential materials. And as the years wore on, he forgot or ignored that he had valuable information hidden away in the closet and therefore failed to remove the book when a different teacher took over the classroom. That's a good reminder that it's so important for employers to conduct regular audits of their trade secrets to ensure that they are correctly accounted for and securely managed. In addition, when Professor Slughorn took over teaching potions, no one told him that one of the old potions textbooks stuffed in the back of the teacher's closet contained anything sensitive or confidential. And that's how Professor Slughorn ended up handing the book over to Harry, completely innocently, having no idea what the book actually contained. That's a reminder that it's so important to clearly communicate to employees exactly what information is confidential and how it should be handled, so that everyone in the organization who handles confidential information understands its significance and the precautions that need to be taken. For example, who might be entitled to receive copies. The mishap with Snape's book is a good reminder to employers that their confidential information needs to be protected not just from nefarious actors who may intentionally want to compromise it, but also from loyal employees who don't think they're doing anything wrong, but who just haven't been properly trained.
Those are definitely some very important lessons for Muggle and Wizard employers alike. What about methods of protecting trade secrets? Jill, do you have any thoughts about what the Harry Potter series might teach us about that?
Thanks, Millie. I think a good example here is the way in which access is limited to the 4 common rooms at Hogwarts. So, as we all know, each house has its own method of accessing the common room, whether that's with a password, so Gryffindor and Slytherin, answering a riddle, Ravenclaw, or tapping out a rhythm for Hufflepuff. The houses are secured by these methods, not just against outsiders to Hogwarts, but even within Hogwarts. The houses are secured against anyone who's not a member of that particular house. So, for example, only members of Gryffindor House need to access the Gryffindor common room, so they are the only ones who are given the password. Applying that principle to the Muggle world, employers would be wise to limit access to their most sensitive trade secret information to just those employees who have a need to know it. That limits the number of potential sources of leaks and can also help the employer establish that the information qualifies for trade secret protection should litigation ever arise. But a few words of caution with using passwords. We all remember the Gryffindor security breach incident involving Neville Longbottom. As I mentioned, access to Gryffindor House is secured by a password that is frequently changed. Now, that's a pretty good tactic, but we see the potential pitfalls with that method when Neville, who has trouble remembering that frequently changing password, writes it down on a piece of paper. Hermione's cat, Crookshanks, then steals the password list, which Sirius Black ends up finding and using to break into the common room. That, of course, is a risk in the real world too, and why two-factor authentication is an important security method. Another password lesson can be learned by Dumbledore's office, which is secured with a password that he changes from time to time. But in Harry Potter and the Goblet of Fire, Harry successfully guesses the password because he knows that Dumbledore tended to use the names of candies. So Harry just lists all the candies he knows until he hits on the right one, which was cockroach clusters for all of our listeners out there. That's a good reminder to make employees choose passwords that are difficult to guess and not just something simple like their names or 1, 2, 3, 4.
Those are excellent examples. Thank you, Jill. Amy, are there any other examples you can think of in Harry Potter that Muggles might draw trade secret lessons from?
Well, another one that comes to mind, Millie, is the Fidelius charm. The Fidelius charm places the secret solely in the hands of an individual, known as the secret keeper, who has the exclusive ability to reveal it. The Fidelius charm, as you may remember, was how James and Lily Potter kept the location of their house hidden from Lord Voldemort, which worked until their secret keeper, Peter Pettigrew, betrayed the Potters and revealed the secret to Voldemort. Just as the Fidelius charm, despite its strength, is vulnerable to the secret keeper's betrayal or coercion, in the real world, when companies repose their trade secrets in individual employees, which they obviously need to do to get any use out of their trade secrets, human error or betrayal is always a risk, despite whatever technological or physical protections employers may put in place to safeguard their information. This underscores the importance of not only relying on agreements and technical, physical security measures, but also fostering a culture of trust and integrity, conducting regular training on confidentiality, and implementing checks and balances to detect and prevent unauthorized disclosures.
That's a really important point because, of course, employers have to be able to entrust their trade secrets to at least some of their employees. While that trust is presumably or hopefully reposed thoughtfully in the right people, the trustworthy and loyal employee you hired might not turn out to be quite so trustworthy or loyal after all if they get offered the right opportunity by a competitor, or if perhaps things sour for them over the course of their employment. Are there any examples in Harry Potter of warning mechanisms or alarm bells if betrayal is at risk? Kristen, what do you think about that?
So in Harry Potter and the Order of the Phoenix, the students form a secret organization that they call Dumbledore's Army, or the DA, to teach practical defense against the dark arts at Hogwarts. Hermione Granger puts a jinx on the parchment that each member of the DA signed to cause anyone who betrayed the group to break out in boils. This is exactly what happens to Marietta Edgecombe when she tells Professor Umbridge about the DA. Not only did the boils on Marietta's face immediately reveal her to Hermione and the other DA members as the perpetrator who betrayed their trust, but she's so horrified by the boils covering her face and fearful of what else might happen to her if she reveals more secrets that she refuses to reveal further information about the DA, beyond its existence, of course. This might be likened to the various automatic enforcement mechanisms that employers might institute, such as software to monitor email traffic and who accesses certain applications or drivers or files. Employers might also have true alarms or logs on spaces or data depending on the nature of their business. Employers can think about these mechanisms as their own Marauders map that tracks the access and movement of sensitive information within an organization and helps employers to be vigilant and look in unexpected places for potential breaches. For example, employers might use software to monitor outgoing emails and detect if sensitive information like individual social security numbers or bank accounts are being sent to unauthorized addresses, in which case that email might be flagged, blocked, or require additional approval before it's allowed to leave the company's network. Additionally, like Dumbledore's Army, employers might have specific internal teams and leverage those teams to assist with protecting their confidential information. For example, employers might have designated IT, HR, security, compliance, privacy, and legal colleagues available to assist and work with the relevant business personnel involved in any confidentiality breach. They may also rely on forensic vendors and trusted outside counsel like Epstein Becker Green in these types of situations. Having these designated teams helps to build efficiency and best practices and make sure that these teams are ready to go in the event of some sort of confidentiality breach. Because the goal in both the wizarding and the muggle worlds is the same: to deter, detect, and respond swiftly to any breach of trust or confidentiality.
That's great. Thank you, Kristen. What about if a breach has already taken place? What does Harry Potter have to teach us about detecting breaches that have already happened?
In Harry Potter and the Goblet of Fire, as you may recall, Harry sneaks out of his dormitory at night under his invisibility cloak with the golden egg, and he almost gets caught when his foot gets stuck in a trick step and he drops the egg, which starts wailing and screaming and draws the attention of Mr. Filch and Professor Snape. They come running over to the base of the staircase where Harry is stuck under his cloak. Filch and Snape know that something nefarious is going on because they see the egg, which could only belong to one of the 4 school champions. It's on the ground in a supposedly empty hallway in the middle of the night. Harry is invisible under the cloak, but they might have caught Harry if they had just walked a couple of steps up and bumped into him, or if they had listened really closely and heard him breathing. But they don't do these things because they look around, they look up, they look down, and they don't see anyone. And as a result, they don't catch Harry, and Harry gets away with it. So too, when employees try to remove trade secrets, they typically try to do so covertly to avoid detection. Of course, you want to check the obvious ways because you never know. You might find something in some of the obvious sources. But if you don't find anything, that doesn't mean that the employee didn't take anything. Employers need to dig a bit further. So, for instance, employers routinely check email files that a departing employee may have sent out of the network to either a personal email or to a third party. If you don't see anything concerning in subject lines or in the attachment names, employers should still open the physical emails, or at least do some spot checks and the attachments, and not just rely on the names. Because it's very simple for employees to try to cover up that they've taken confidential information by naming a file or titling an email personal and then taking that information anyway. Employers should also check the trash and see if anything was double deleted working with IT, because an existing inbox or a sent file may not show you everything that was on the system and tell you the entire story. Employers also shouldn't overlook printed materials. For example, I once heard of an employee at a company who had 3-ring binders on shelves in her office with confidential deal documents. She left to join a competitor, and it took some time for the company to realize that while it looked like the binders remained intact on her shelves, they were actually just empty shelves because she had removed the documents and left the binders behind as a decoy. I also recommend that employers review badge swipe access, if you have that, to your physical premises, and possibly security footage, because you might be surprised who's coming and going at weird hours leading up to a resignation or even after a resignation. Employees may come on the premises to remove materials like computers or other printed materials, and they might be recorded on camera having done so. I once heard of an instance where an employee took a few laptops and some other physical property from an employer and took so many documents that he actually needed a hand truck to help assist him with getting them to his car. Employers are also going to want to review their systems and preserve an image and potentially review the individual data that's on computers and phones. They're going to want to check text messages, call logs, documents that are saved locally, internal messages in their messaging platforms, and their client files. You can find a treasure trove of information and see what employees' patterns are by reviewing these documents. You may also want to check employees' photos. I've been aware of instances where colleagues have taken pictures of restricted materials in an effort to try to get that out of the network because they think that employers may not be looking at everything. You may also want to grab some of your old-fashioned call logs and text logs, even if you're planning to review the individual phone, because they may show patterns of calls a bit quicker. And if a phone is inaccessible or destroyed, for instance, you may not be able to rely on that data, and you'll at least then be able to see that the colleague may have been up to something on the day or time period leading up to a resignation or departure. It may also help to identify new phones, or, as we like to joke in the industry, burner phones that people may use to try to cover up their tracks. And just pro tip in discovery, remember that all personal data repositories may be available to you as the opposing party. So you want to make sure that those are covered off as well. And the same principles apply when you're onboarding a new colleague that apply to when you're looking for what your former colleagues may have been up to. New hires may not always remember that they have confidential information from their prior employer. So you as the new employer want to make sure that you keep that stuff off of your system to proactively address potential issues before they balloon into a really big issue. So the lesson from Harry Potter is that when employees who had access to sensitive information leave, employers need to be creative and walk up the stairs a bit to keep pushing for information, even though it may look like none is there. And that same lesson can be applied when you're onboarding as well.
Thank you, Kristen. That's great. So to wrap things up here, I have one final question to each of our panelists. If you could invent a spell to enforce restrictive covenant or confidentiality obligations, what would it be called and what would it do? Kristen, do you want to go first?
So I would invent a faithful bond, the fidem vinculum. This spell would magically reinforce the commitment to restrictive covenants, ensuring that anyone who tries to breach their obligations would be met with an immediate reminder of their promise.
Amy?
I would invent a silence keeper spell, or silentium custos. This spell would create a protective barrier around confidential information, ensuring that any attempt to leak it is met with a silencing charm.
I love that. Jill?
So I think I would invent a truth tenacity spell, Veritas Tenacitas. This spell would instill a sense of integrity and loyalty in employees, ensuring that they think twice before breaching their obligations.
Well, those are all excellent ideas, and if only it were that easy in the Muggle world. Thank you to our panelists, Kristen, Amy, and Jill. This has been an enchanting discussion and a lot of fun, and I think you've given our listeners a lot to think about and some really excellent pointers. I've thoroughly enjoyed celebrating Halloween with you.
Thank you, Millie, and
Thanks,
happy
Millie.
Halloween to all of our listeners.
Thank you, Millie. Happy Halloween.
A special thank you, as always, to our listeners. If you would like to subscribe to the show for free, please go to ebglaw.com/subscribe and click the box for Trade Secrets and Non-Competes Spilling Secrets podcast series. Thanks again for joining. Until our next episode, this is Millie Warner signing off and wishing everyone a very happy Halloween on behalf of the Spilling Secrets team.
This podcast is presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.